Judge Cannon stuns Jack Smith. She issued a new order that says, you guys got to get together, both the prosecution and the defense, and come up with some jury instructions that we can use when this case goes to trial. The problem for Jack is that the jury instructions show how weak and pathetic his case is, and if the jurors read it, they're going to know that this case probably shouldn't have been brought and that Trump is in fact not guilty of any of the alleged crimes. And so the left is very unhappy about this order. We've got Weissman, we've got Conway, and others very upset. They say, how dare she do this? She should recuse herself. She should be removed from this case, or there should be a mandamus from the Court of Appeals to force her to do stuff. Of course, they have a different opinion about Judge Chutkan when she, in my opinion, wrecks the Constitution with every one of her orders. So it's just them forum shopping. They don't like that every single judge is in their back pocket. And so let's take a look at this very beautiful order that dropped from Judge Cannon. March 18th, out of the West Palm Beach Division, Southern District of Florida, Jack Smith versus Trump and the co-defendants. Judge Cannon writes this: all right, everybody, you, Jack Smith, and Donald Trump, the defense, everybody must follow this order. Says, all right, everybody. On or before April 2nd, coming up soon, Trump and Jack Smith each shall file proposed jury instructions limited to the essential elements of the offenses charged in counts 1 through 32 of the indictment, right? So whoever gets to decide the rules typically wins the game, right? We all understand this. If you get to make up the rules of the game, you can win, unless you're, an ultra fair person and, try to be fair. But if you ultimately make them up, you can win. So there's a big battle over what happens with jury instructions. And Cannon wants both sides to brief it. Now, only the first 32 counts, which are the counts involving all of the documents. Each separate piece of paper that was classified, they charged as a crime. So I want to know what we're going to tell the jurors about those documents. And I also want a proposed verdict form for those counts. So I need to know what they're checking off or not. Now, she also gives us a footnote. Instructions beyond the substantive contours of the counts, not part of this order, but defenses that are intertwined with the statutory definitions are so contained. The standard 20-page limit for memoranda of law does not apply to the ordered submissions. She says, so moreover, now understanding that juries are judges of the facts, not of the law, the proposal shall take care to specify, in incorporated briefing as necessary, exactly what factual questions are reserved for the jury on counts 1 through 32 in light of the recently argued motions to dismiss. And we had several motions that we talked about here. Selective and vindictive prosecution, which was argued but not filed. Publicly, it was filed, but we didn't see it or read it. But we also had the idea that the charges were void for vagueness because nobody knows what they mean as applied to the presidency. And we also had the motion to dismiss. There was another one based on the Presidential Records Act, and that one has not been ruled upon yet. Void for vagueness was already denied. So with respect to the proposed language pertinent to the unauthorized possession, specifically the parties must engage with the following competing scenarios and offer alternative draft text that assumes each scenario to be a correct formulation of the law to be issued to the jury while reserving counter arguments. Okay, so this is big. These are the rules of the game. And you guys read these and let me know what you think. But be prepared to talk about these scenarios in the formulation of these instructions. So here's the first one. Now imagine if you're Team Trump saying, I want these rules to benefit our client, our president. Let's see how this sounds. In a prosecution of a former president for allegedly retaining documents in violation of the law, a jury is permitted to examine a record retained by a former president in his or her possession at the end of her presidency and make a factual finding as to whether the government has proven beyond a reasonable doubt that it is a personal or presidential document using the definitions set forth in the Presidential Records Act. Now, you can also include separation of powers or immunity concerns if relevant, right? So the jurors are reading these instructions and they're saying, okay, all right. Then a president, okay, they say, okay, according to the definitions set forth in the Presidential Records Act, right? Okay, well, what does the Presidential Records Act say about this stuff? How about this? A president has sole authority under the Presidential Records Act to categorize records as personal or presidential during his or her presidency. Whoa. Yeah, that's like kind of the game, right? Because they're saying, no, he doesn't. Deborah does from the National Archives. Sorry, right? The DOJ does. They get to classify this stuff. No. And she's just following prior precedent from the Obama-appointed judge, Amy Jackson, I believe. Or was it Amy Totenberg? One of the two judges, right, said that Bill Clinton is the sole authority to decide whether you can access his sock drawer or not. So if that is the jury instruction, that's like the game. Now, neither a court nor a jury is permitted to make or to review such such a categorization decision. Whoa! That's the rule. Now, although there is no formal means in the PRA by which a president is to make that categorization, an outgoing president's decision to exclude what he or she considers to be personal records from the presidential records that are transmitted back into the archives constitutes a president's categorization of those records as personal under the PRA. Woo! Okay, so this means that Trump taking the boxes out of the White House and not giving certain documents back over to the National Archives is his categorization. He didn't have to fill out a stupid form for Deb. He didn't have to go through some formal declassification or get permission from his chief of staff or see what the DOJ had to say. No, you take the boxes, they're yours. You're the president. If you have to fill out a form to get permission from someone else, they have more power than you do. That's just how it works. It's been obvious from day one, and Judge Cannon is getting that, right? So that's huge. And Trump is going to make that claim about every single document. Now, there might be one document, which is the nuclear code document, which may not be an executive branch agency. So maybe he doesn't have a claim to that one. But, for the rest of the counts, that is a rock solid jury instruction. Okay, so you can see why they are so freaked out about it. The president has the sole authority, and no one gets to question the president. You guys don't even get to decide, like jurors. You don't even get to decide. No formal means by which he has to comply, and it cannot be questioned. So that's kind of the game, right? It's huge. That's huge. So they're obviously freaked out big time about this. Absolutely raging. So here is what Weissman posted on X. He said, "This is the kind of legal inanity that could lead Jack Smith to seek a mandamus, to get the 11th Circuit Court of Appeals to hear this and reverse her again, which could also be the proverbial 3 strikes and you're out." So they're trying to get rid of Cannon. Other people very upset about this. Here is what Bradley Moss said. He said, "The second scenario is legally insane. If that were the case, then just grant Trump's motion to dismiss on the PRA grounds so the DOJ can bring it up to the 11th Circuit for a reversal," right? Just saying, let's go. They're not happy. And Conway said, "Okay, I've seen enough. Not only should Cannon not be sitting on this case, she should not be sitting on the federal bench at all. This is utterly nuts." And I don't think so at all. I think it's actually how it works. You know how we know that's how it works? Because Clinton didn't get prosecuted. Neither has any other president for taking any other documents before. It's all just now changed because of Trump. And she is just creating that precedent. So this is Weissman. Now he was over on with MSNBC. They were melting down over this ruling. And here is what Weissman says in response to this decision.
Andrew Weissman, I have never seen a draft jury instruction quite like it. What are Jack Smith's options here?
Well, there's a reason you've never seen anything like it. I don't think Bradley and I have either. Last week, Bradley was trying to come up with the best Yiddish phrase for this. And I have sort of 2 M words for you. Meshugana, which is what this is, because the choice that was given by Judge Cannon to the parties is to ask Jack Smith, so please draft a jury instruction assuming that the earth is flat. Mm-hmm. And the second one is please draft a jury instruction assuming that the earth is square. And so the second M word is mandamus. Mandamus is the ability, it's not an appeal, it's for extraordinary actions by a district court that so clearly violate the law that you can appeal it right then and there. It's a very tough standard. At this point, what she did today is so nutty so against a point that Bradley's been making, which is that the 11th Circuit has actually already decided this issue, and what she has proposed is against what the 11th Circuit has already reversed her on. So I really think, to the extent that you think that she is engaging in partisanship, which I do, there really has to be a time that you take her up on and you do this mandamus to get to the 11th Circuit before she gets to trial, because that's when she has the unilateral ability to throw this case out, and it cannot be appealed.
All right, let's see. So they're very upset about it, and I think it makes total sense, right? It's the Bill Clinton precedent. If Bill Clinton is the sole arbiter of the document categorization, so is Trump. She's following his precedent. Only other situation even remotely resembling this, they always say that, this is unusual and this is so strange and we've never seen anything quite like this. Yeah, you're right. We've never prosecuted a president before. You're right. Congratulations. Your side did that. We've never done this before in 234 years until you guys broke glass. So that's why it's different. Don't act like this is some new thing because this is regular criminal procedure or something like that. Like this is out of the ordinary. Like if Judge Cannon did something like this in a regular DUI case, you'd be like, okay, that's a little bit strange. Like where'd that come from, right? Where would something unusual unusual come about. This whole thing is unusual, and Cannon is returning it to normalcy by referring back and following the same precedent that the Weissman guys and Team Lefties decided when they were protecting Bill Clinton. You don't get to protect Bill and then suddenly say all of those rules don't apply to Trump. Can't have it that way. So it makes total sense from our perspective, but they're not happy about it. Judge Cannon demanding orders and ordering responses. We're going to see what they look like, and we'll be covering them when they drop here, my friends. And so thank you for subscribing to our channel. Thanks for joining us and inviting someone you know or love to come and join us when we go live here on the show. It's a great way to help other people see what's happening in all these cases, and we'd love to see you and them, of course, back here. We also have some great links down in the description below. RobertGouveia.com is where you can sign up for our newsletter, access all the PDFs we cover here, and watchingthewatchers.locals.com is our members only community. So if you want some extra content in the mornings and some Saturday streams, come join us over there. We'd love to see you there and back here on the next one.